Hello, everyone, and welcome to today's Bloomberg Law webinar. At this time, all lines are in a listen-only mode, and the floor will be open for questions following the presentation. Please submit your questions via the Q&A tab and technical support questions on the Tech Support tab on the right side of your screen. To access the PowerPoints or other files associated with this webinar, please click on the resources link listed in your upcoming webinars or recent registrations on your dashboard. If you wish to receive credit for this webinar, please make sure to respond to the presence check codes popping up on your screen throughout the webinar. You will need to respond to the majority of these codes in order to receive credit. Please fill out the webinar evaluation survey as well as confirm your certificate information at the end of the webinar. Your certificates will then be emailed to you. If a jurisdiction is pending, you will you will receive the approved certificate via email as soon as it is available. If you have any questions about continuing education credits, please email us at credits@bna.com. Before introducing our speakers, I would like to thank World Services Group for sponsoring today's webinar. WSG offers immediate access to distinguished professionals and firms recognized within key industry sector globally. I would now like to introduce the speakers for today's webinar: Cross-Border Deals Today and Tomorrow, Artificial Intelligence and Minimizing Risk. AJ Bahu is an intellectual property attorney who focuses on the intersection of law and technology. A registered patent attorney, trial lawyer, mediator, and arbitrator, AJ has extensive experience in the areas of electrical and computer engineering technologies, including blockchain, virtual reality, medical devices, computer hardware and software, and Internet security systems. John Lash provides critical strategic expertise at the intersection of business, technology, and operations, developing innovative solutions during times of change and transformation where budget, reputation, and performance outcomes are at risk. Eric Lavallee is a lawyer and trademark agent in the Business Law Group, and he runs the Lavery Legal Lab on artificial intelligence. As a result of his extensive experience in intellectual property, Mr. Lavallee took on a special interest in developments relations to artificial intelligence over the past few years. Edward I do apologize, Edward.
Sturcio, you're right.
Sturcio is the Global General Counsel and Secretary of Advanced Accelerator Applications, SA. In this role, he is responsible for worldwide legal functions across 22 sites in 13 countries. And with that, I would now like to turn the presentation over to John Lash.
Thank you. So what we're going to do to start off the presentation is really define and set a foundation for artificial intelligence in the M&A context. At its most basic form, AI is simply the ability of a machine or computer to act and learn. Right now, a truly artificially intelligent system would be one that can learn on its own, making connections, researching meanings without relying on any predefined behavioral algorithms. The true AI improves on past iterations while getting smarter and more aware. Right now, presently, we have kind of an augmented AI, which is more fundamental technologies, behavioral algorithms in an Amazon or Google context, suggestive searches within Bing or Google, and we're moving towards autonomously powered self-driving vehicles. So true AI is still a little bit off, but we're in a current climate of modified AI or augmented AI. In the M&A context, what we want to address is with the high level of investment coming into the United States, there are high value targets. very few resources right now are considered as valuable as data. And utilizing data coupled with the current sophisticated analytical and manipulation techniques, such as AI, allows for companies and governments to extract even more value from that underlying information. So as funds and investment come into the United States, it increases the risk profile of the transaction. The ability to utilize these technological advances such as AI to leverage that raw data to support command and decision making, enhancing military education, upgrading defense equipment, and establishing other military civil fusion activities has really created a bit of a paradigm shift as it relates to data vulnerability in today's M&A world. Moving into weaponizing that data and information, this has become a critical aspect of how the United States evaluates FDI, and this is most colloquially known as CFIUS, the Committee on Foreign Investment in the United States. So weaponizing that information via AI or data manipulation techniques does allow the ability for controlling entities to potentially engage in malicious activities against the interests of the United States, contributing to loss, whether that's economic, IP, technological advances, or other adverse effects that may impact national security or national public health. These range from the ability to identify key U.S. personnel, whether domestic or abroad, performing social network link analysis to identify potential intel vulnerabilities or counter intel vulnerabilities, performance of geospatial or temporal analysis, or just to establish basic mosaic interpretations related to U.S. public health and safety, do create critical data threats that must undergo risk-based assessment models as we consider how AI impacts data and how that impacts foreign direct investment in the United States.
Hello, this is AJ Bahu. I'm going to talk a little bit about tools that might be used around the world and in cross-border transactions that deal with that data flow that was just mentioned. And one example of a new technology that's forthcoming is blockchain technology. And at its core, it's a cryptographic distributed ledger. This implementation of technology allows companies and entities to use what's a quasi-public database to keep a permanent record of digital transactions. And while that's important going forward with artificial intelligence and cross-border deals, is very simply this, is that when that data is stored in the cloud or accessible by the internet, all of that information then becomes a storehouse for artificial intelligence systems to mine. An artificial intelligence system is only good as the data set that it uses to make those decisions and then act and learn from those decisions going forward. So blockchain technology might be one example of a public available database or a public store of information. Even though some information on that blockchain might be kept private, that will be an example of a tool going forward that artificial intelligence can use to mine that data and then consider the data set for decision making. By way of additional example and giving you a picture on the screen, I have a variety of clients in the blockchain space, but then separate clients in the artificial intelligence space. What we see happening with regard to transactions going forward is that using an artificial intelligence system is a way to collect the data sets that are out there and are available. And so the screen, as you see on the screen right now, that's one blockchain as a service that shows the connectivity of potentially smart watches, which you see as purple there in the center, smart refrigerators, water meters that are connected to the internet, but also other appliances and that type of thing. That's one simple example, but as our businesses become more connected, there will be more data that's publicly available or at least accessible by the internet. And there might be a reason that researchers want to have a worldwide access to a data set, and this technology might be a way in which blockchain is used and artificial intelligence is used together to collect that data, make decisions from those data sets, and then go forward. An additional application of artificial intelligence and blockchain is to speed up the transaction and processing of data and recordation of data on the blockchain. So that's one example of a tool, and I'll turn it over to the next speaker now.
Thank you, AJ. So we've heard John and AJ explain to us what AI is, blockchain, why it's important for our deals. And when we drill down into the aspect of AI in relation to cross-border deals, we can see that digital technology generally, and particularly AI, permeates really almost every aspect of the M&A landscape. Banks use it to assess deal opportunity, to determine trends in domestic and cross-border deals. They conduct in-depth target analyses to determine whether a company may or may not be picked up by another company as a target, whether a particular target might be useful or a good target, good fit for the acquirer or potential acquirer. Certainly throughout various aspects of due diligence and even post-close integration. So you can see that AI really does permeate every aspect of our cross-border M&A deals. So how do we determine, okay, we've determined that we want to use AI or might be useful to us, and so how do we determine then what AI is useful and how to deploy that AI to our best benefit? The first tip I can give is really to leverage AI that may be in place by others, your investment banks, counsel, your executive management consultants, M&A consultants. Cost and timing may often be prohibitive for companies themselves to establish AI from scratch, and a lot of them may not have access to the big data needed to generate the useful results that they might be looking for. So if you look to the sectors that are really leading this charge, it is the investment banks, large law firms, outside consultants, M&A consultants, executive management consultants, and certainly some companies themselves. So and Deloitte recently in its 2018 M&A Trends Survey said 63% of companies are using some new M&A technology tools, and that includes AI to a large degree as well. So how do we choose what AI is best for our particular companies? Well, as a GC, we look to who is bringing the AI to the table, who is the provider. Do they have, how robust is their AI product? Do they have access to big data? So you'll find out that as I speak here just for a moment, the better the data, the more the data, that tends to drive better results. The inputs are determinative of the outputs. You are what you eat, so to speak. There's a cost aspect to it, obviously, that's going to factor into any decision. And then there's a liability or compliance aspect that we're going to talk about a little bit later on. The value add of AI, again, comes in different flavors depending on what segment of the deal we're talking about. But to select the best AI, again, assess its capabilities, its inputs, and your particular needs. You can see banks, law firms, M&A consultants, they've all used deep amounts of historical data to develop predictors of the various things that we talked about. Is this target a good target for our company? Is there deal opportunity where they might not have historically organically seen this? And then what's maybe post-deal, post-close integration ease? They can assess all of those factors using certain AI pieces. So to understand what AI is best, I think you really need to understand how AI learns. You just heard that AI learns from these machine learning technology offerings, learn from examples, amassing historical examples. AI is effectively, quote unquote, taught to recognize in the due diligence area, for example, abstract legal concepts like assignment or change of control. But it can make mistakes, and we'll talk about that later. So how do you overcome some of these potential quality challenges? It's with good quality inputs and massive quantities of inputs. You can try to overcome some of these quality problems by making use of massive amounts of big data. In other words, looking at millions and millions of historical patent filings, text from numerous due diligence cases, and of course, historical deal data to make the best possible conclusions. The easiest way to improve that predictive algorithm is to improve the quality and quantity of data. It's as if you are a physician who's had years and years of medical practice experience. It's effectively having the life experiences of a 50-year-old at age 1. You've heard that saying, I wish I knew then what I know now. It literally is knowing then what you know now by putting in all of these massive data inputs. You can see the example that let me forward the slide. You can see the example that I've put in place here, to give you an understanding of what some of these offerings look like. And I wouldn't want to name, and I don't even recall the consulting company where this came from, but having analyzed mass amounts of historical deal data, they have indicated that they've been able to estimate the probability of acquisition for more than 25,000 public companies. I assume there might be some limitation, again, for private companies where information might not be available, but if what they're saying is true, that could be a major competitive advantage that would have tremendous benefits to cross-border deals. Again, if you think of the AI systems as factories, the widgets or decisions, the end product, are only as good as those raw materials. So when evaluating whether to use AI and how to assess one system versus another, it's really important to look at those raw materials. As you understand that AI learns and improves on its own by amassing massive amounts of data and better data, the quality of that data and the amount of it obviously becomes critical. Some other factors, obviously there's an access to big data issue. Not everyone has access to that data. It would take, I imagine, thousands of man hours and resources to start from scratch if a company were going to want to do that, but there are others out there. There's a cost aspect to it as well. There's a cost-benefit analysis to it, particularly when you think about cross-border deals where you have a tremendous amount of attorney time invested in things like due diligence and all those aspects, which we'll talk about a little bit later. And then there's a liability component, which we'll focus on a little bit as well. You're going to hear this again today, but it bears mentioning here. Commentators agree that machines make mistakes, right? People drive into lakes while blindly following their GPSs. How we assign liability and calculate those damages is going to become critically important in assessing whether we want to employ AI and exactly what systems we want to employ. We talked about cost, we talked about liability, when we're going to focus on the potential for some mistakes and liability as we continue the dialogue. And now I'll turn it over.
Okay, thank you. This is Eric Lavallée. Looking at cross-border deals about AI technology, one of the challenges comes from the difference in laws and regulation from one jurisdiction to another. Looking at patents, there are some substantial difference in the guidelines and how the laws and regulation apply, depending on the country where you are. Given the pace of the development in AI, when we're doing a deal, we are often working with patent application before any patent is granted. That means that we often have to assess whether or not these patents have any chance of being granted in the future when we're looking at the acquisition of a company who owns a patent portfolio. Contrary to more conventional patent application on conventional technologies, we cannot take for granted that if the application seems to be acceptable in one country, that it will be likely granted in another country. If we look at the U.S., obviously, the Alice CLS Bank decision from a few years ago had a major impact, and we've seen a few patents on AI technology fall in court. And certainly many common AI applications seem to be unpatentable now. Meanwhile, we have a lot of companies that continue to file patent application, and we see also that some patents are granted for AI technology, especially when we look at the fields of robotics, for example, but also when you have interaction between several different systems, for example, the use of blockchain information, distributed information, which is analyzed through AI. If we just cross the border up north in Canada, the picture is already more nuanced. A few years ago, we had the Amazon decision where the Amazon one-click buying method was granted a patent, and it was through a trial that where the court said that computer implementation could be an essential element of a valid patent. We are still hoping for more specific decision on AI system, but there certainly seems to be a potential to file some patent application in Canada. Meanwhile, in Europe, Article 52 of the European Patent Convention exclude programs for computers. So it would seem at first glance very clear that no patent could be granted on the AI programming itself. However, a patent may be granted if a technical problem is solved by a non-obvious method, which in some cases may give you some limited potential to file a patent application on AI technologies which are applied to some specific technical problems. And if we look in Japan, according to their examiner guidelines, software-related patents can be granted for invention which are concretely realizing the information processing performed by the software by using hardware resources, which is the wording that is used in their guidelines, but I think it would be easier to get a patent granted in AI in Japan based on this wording as long as we involve some hardware aspect to the patent application. But we end up having to do a deal which may result in various patents being granted or not in different countries. So when you're looking at an M&A to acquire a large patent portfolio, you have to keep that in mind. And of course, there's always this question whether or not patents or the inventions regarding AI are obvious or not, because neural networks have been around for a long, long time. Even more advanced technologies like deep learning have been there for about 20 years now. So sometimes you might have what appears to be a very good invention, but it might not be patentable because it's known art, previous art. Looking at copyright, we also have some difficulties, and in this case, we have difficulties, among other things, for the work which is created by an AI system. We have seen recently AI system creating some visual art, some music. The artistic value of these may be disputed. However, the commercial value can be very important. For example, if an AI creates the soundtrack for a movie, I was talking just yesterday with a programmer who was telling me that he was developing an AI system which would eventually program software, make the source code for software and gaming industry. So itself, the AI will be able to create some work in some kind of semi-autonomous way. And some jurisdictions do not give copyright to work created by machine, like U.S. and Canada. In Canada, some recent case law specifically stated that for a work to be protected under the Copyright Act, it need a human author. So in this case, we would have no copyrights on the work created by the machine. In the U.S., some of you might remember Naruto, the monkey that took a selfie. In the end, there was no copyright on the picture. While we are not sure on how this will translate for AI at this point, it is difficult to foresee that an AI system will have any IP rights if a monkey has none. An AI system is generally less embodied, less intelligent than an animal. Although it can process very complex information, it doesn't have personal rights. So we end up, again, in the U.S. with a situation where it's not obvious how you can protect the work which is created by an AI. Meanwhile, other jurisdictions like UK and New Zealand have created legal fiction, whereas the programmer of the AI will likely be the owner of the work created by the computer. These changes, which date back in the 80s and 90s, were not specifically made with an AI in mind, but it is likely that the broad language that was used will apply. For example, in UK, where copyright is granted to the person by whom the arrangements necessary for the creation of the work are undertaken. So, with such legal wording, we can hope that the work from an AI will belong to the person that are the manager or the guardian of the AI system. So you end up once again in transborder deals with some work which is of value that may end up having no protection at all in some countries and very strong protection in other countries. Now, there's also the concern of data privacy. A French colleague was telling me recently that if construed literally, the European GDPR are difficult to reconcile with some AI technologies. We just have to think about the right to erasure and the requirement for lawful processing, or if you prefer, the lack of discrimination, which may be difficult to implement. If we look at what does a neural network, which is a part of most AI systems now, they typically learn from data sets created by humans or directly by human training. Therefore, they often end up with the same bias as the person who trained them, and sometimes even more bias, because what neural networks do is they find patterns. That's their strengths, the way they function. They might end up finding a pattern and optimizing a situation, for example, trying to find the best mathematical solution to optimize a business problem while having some unacceptable racial or sexist bias because they do not have human values. They are just mathematical tools in the end. Furthermore, there are challenges when working on smaller data sets that allow reversing the learning of the AI, the learning process, as it may lead to privacy leaks and trigger the right to remove specific data from the training of the neural network, which is itself technically difficult, but is a requirement of the GDPR. Looking at other jurisdictions, you have to take into account laws and regulation which are specific to some industries. Just one example, which is very interesting from the AI standpoint, in the health industry, they are the HIPAA compliance in the U.S., which includes some privacy rules and some technical safeguards. You also have policies which are decided by local government agencies and which need to be met in order to have access to some government data. For example, the access to the province of Quebec's electronic health record, where I am located, which has its own set of safeguards and technical safeguards, privacy rules. And one of the challenges in such cases is to come up with a solution that comply with all applicable laws in all these different countries. So in some cases, you may end up creating parallel system, even creating sister companies which are not controlled by necessarily the same entity or are governed by their own set of rules if the technical requirements or the legal requirements are not compatible from one country to another. Finally, another issue is that the liability. If the AI fails and causes damage to a third party, once again, you may end up with a variable consequence depending on the jurisdiction. I have seen a colleague from another jurisdiction recently use a defense in a litigation that, well, basically nobody was liable for the damage caused by the AI system since it was autonomous, whatever that means. I doubt this will succeed. At least in most countries, the guardian will be liable for the damage caused by the equipment under its control. Certainly, the absence of will of a computer will not be a factor in strict liability offenses. But if we go back from a tort and civil liability perspective, it may be required to show that reasonable efforts were made to ensure that the AI system would not cause damage to third parties, for example, by relying on some reasonable safety standards. The question remains, however, which safety measures will be sufficient in each jurisdiction, which standards must we comply with, and there's no clear answer to that presently. If something goes wrong, probably the guardian of the system will be liable, but probably also the programmer if it did not take proper measure to avoid causing damage to third parties. And very importantly, also in line for liability, the provider of the training data sets, which will have to make sure that he provide data which are adequate and will not induce, for example, unlawful bias. The data sets more and more are provided by third-party companies that have access to this data. In the end, if the data is the source of the problem, you may end up with some liability, and it might become very challenging if the data is gathered in one country but then used to train a system, an AI system, which is operated in another country where you have another set of rules governing the privacy and the bias. So I'll turn now the presentation back to AJ.
Thank you, Eric. And now adding on to what Eric's saying about the potential liability, I wanted to touch briefly on the cybersecurity related concerns. First of all, if you're doing a merger and acquisition deal, especially cross-border, as Eric mentioned, there are a lot of regulations to consider and a lot of different respective jurisdictions. So at a high level, your participants want to consider what hygiene, the cybersecurity hygiene the companies have been understanding and participating in, as well as potentially negotiating some concerns going forward, whether liability remains with current actors or carries forward with a new entity in a merger and acquisition. So just at a very high level, one example of good cybersecurity hygiene is two-factor authentication, and at a technical level, this might need to be discussed to make sure it either works into the agreements or not. Again, a decision for the business makers at the time, the business officials, that is. But if, in my experience, two-factor authentication is critical. That is, by way of further example, when someone has a username and password, one factor of authentication, something the person knows, and then a second factor of authentication, usually something the person possesses. If that type of authentication is used in the system, it's much stronger. And so by way of tips and practice pointers, I would strongly encourage that to be considered in a merger and acquisition deal, not so much to drive the deal or to highlight any other concerns, other than to say that if this hasn't been implemented on some level in the organization that's being discussed, you might want to be more concerned about potential liability risk with regard to data privacy. And so, and if it's not not implemented in the past, I would consider that you talk about at the negotiation table implementing it going forward for critical data assets. And in that way, if you're going to protect the data sets that are being used in artificial intelligence systems and other, worldwide computer-based systems, you want to make sure that those assets are protected, those data sets are protected, because as we said before, as Eric and John and others have said, the idea that liability might arise, you want to be able to control that going forward. And so two-factor authentication can help in that way. Also, consider training for the humans in the organization. Again, cross-border and trans-border merger and acquisition deals often include companies or entities from different areas, and they might have some level of sophistication, and others might not have that level of sophistication. So as part of the transaction, consider what state the companies are and what their cybersecurity policies and procedures have been before, but then also work to have a holistic approach to training the humans, because they're often the weakest link in the organizations. And so that might factor into some of your merger and acquisition considerations to assess the liability, but also put together the right mindset for the deal going forward to guide the business leaders on, how important it is to protect the artificial intelligence data sets that might be discussed. The last item I have there on the slide is the ability to encrypt data. So at one level, we're talking about artificial intelligence systems. They're only as good as the data that's fed into them. And, as Edward said earlier, I wish I knew then what I know now. The idea being that once you compile these data sets from a bunch of different potential actors, and you try to improve both the quality and quantity of this data, you might be getting it from a lot of different sources. As a merger and acquisition consideration, then you want to ask, what have the companies done with the data before you actually get it or before the deal is about to go through to protect that data? Encryption is one example, one technology that is often discussed. It is a burden on the system, because in order to mine the data, someone has to have the key to decrypt the information. But it's potentially useful in also having that level of protection for liability to say, our data hasn't been encrypted to a certain level, for example, 256-bit advanced encryption service level, and that will help potentially understand the state of the data and then potentially discuss, what needs you might have in the system for protecting the data going forward. Turning now to the next slide. As Eric has mentioned as well, there are a lot of privacy-related issues that are implicated by discussing artificial intelligence systems. So when thinking about cross-border transactions, you might want to consider the laws of respective jurisdictions. As mentioned earlier, the GDPR, the differences between the UK, Australia, the US, and any other jurisdictions that your companies or vendors and entities might be located. So consider those as you put together a merger and acquisition deal, because you want to find out the status of the liability currently before the merger and or acquisition, and then what the organization can handle or stomach going forward. With regard to global privacy issues, this raises the level of expectation in considering an AI, an artificial intelligence system that is searching global data, right? So we've got now potentially the system that is making decisions based upon data that might come from the U.S., might come from the EU, and might come from Canada. In this implementation, you might want to make the users aware, partners or others aware, that if the data is used cross-border, you might want to consider policies that prompt the users to say, if U.S.-based data is being used, these rights might apply. And if EU-based data is being used, these rights might apply. And so in that way, I think that what I'm recommending here is to consider a global privacy policy, not from a master document standpoint, but from a standpoint of categories of jurisdictions that you might need to apply based upon who's actually using it, what data is being used, and other considerations. Turning next to the data transfer mechanism, in this regard, the companies and activity that is going to be happening cross-border in the future is going to need to consider necessarily what is happening with the piece of data. And there's two ways to look at it. First, if the data set that's being mined is based in, a GDPR jurisdiction, but it's being accessed from the United States, what implications does that have for the businesses that are actually mining that data in the AI set? If one view could be that if a server in the United States is mining data in the European Union, but doesn't use any ultimate output of personally identified information, then maybe you're less concerned about the considerations. However, if that data is mined and then a report is given out as the best contact leads for potential business, then that is potentially implicating personally identifiable information and or healthcare and or other types of information. So consider the data transfer mechanisms in any systems that you're evaluating, artificial intelligence or otherwise. And one example I have there under the data transfer mechanism heading is consider that smart contracts on a blockchain might be able to help that data flow in the future. Again, if you're using artificial intelligence in tandem with blockchain, the idea being that you mine the data and then before the data is actually transferred, the smart contract validates whether there's any identified information in there that might be subject to a jurisdiction that you're transporting the data from, and then separately consider what additional requirements and regulations might be implicated by importing the data to a new jurisdiction. Also, another technology aspect that might be helpful in data transfer is considering allocating where the data comes from based upon an IP address. And so there are computer systems now that are called DLPs, or data loss prevention systems, that can categorize data with leaders in the organization and say, if this is HIPAA information and it's based upon U.S. citizens, don't let anybody outside the United States mine this data. And likewise, if it's data based in Canada and someone from the EU is mining that data, there might be technology support that says we're going to limit the ability to access certain data sets based upon where the person is originating the request from based upon their IP address. And I understand this is technical, so again, we've got a question for window for questions, so feel free to add those to the queue and we'll handle those at the end. The third bullet point under data transfer mechanisms is using technology to control access from certain jurisdictions. And by that, if you have an ultimate consumer that is logging on to a web page, for example, in one jurisdiction, you might consider a technological feature of geo-blocking that is preventing certain type of actors or certain categories of participants based upon a geo-blocking feature that, again, somewhat related to IP address, but also has other features in that ability for technology to help you manage the data transfer. Lastly, I wanted to highlight for the listeners today the categories of data, understanding that, as Eric and others have said, that with AI, the quantity and quality of data might include a bunch of different potential categories of data. For example, consumer data, financial data, marketing data, employer-related data, research, health, biometric, and other national security-related information. So the different laws might apply to the different categories of data, and you might want to think about how to organize any policies and procedures going forward that are implicated based upon the AI data that you're either mining or the types of systems that you're creating in the artificial intelligence world. I'll pass to the next presenter.
Thank you. So at this point, we're going to cover a relatively complex issue from a regulatory standpoint all in one slide. So I'm going to walk through a lot of various concepts about foreign direct investment into the United States. So from a fundamental standpoint, the Committee on Foreign Investment in the U.S., known as CFIUS, has jurisdiction over foreign direct investment in U.S. companies or U.S. operations. This colloquially falls into critical infrastructure sectors, which are 16 sectors who have assets, systems, or networks that are considered vital to the United States, and their incapacitation or destruction would have a debilitating effect on national security, national economic security, or national public health and safety. And as AJ walked through the different categories of data at the end of his last slide, in fact, all of those categories of data have been denoted as national security data in recent transactions. So CFIUS, having jurisdiction over foreign direct investment into the U.S., becomes critical in FDI in the U.S. and maintaining national security. FIRMA, which is the first bullet, the Foreign Investment Risk Review Modernization Act, was passed as a bipartisan effort in both the House and Senate in 2018 and was signed into law by President Trump as part of the Defense Authorization Act. That was a bipartisan effort to address the evolving threat environment that's being exacerbated by the data economy, weaponizing information, and artificial intelligence cognitive computing concepts. How that impacts foreign direct investment is, over the last 18 months, over $200 billion of incoming deals have been abandoned. Q2 2018 was the first quarter in years where FDI into the United States went net negative. Now, that's a critical component in understanding how investment impacts the United States economic interest and worldwide economic interest. And much of that is because of these evolving threat environments that are hugely technological. Now, these deals on national security grounds aren't what people colloquially think of as defense industrial base, energy sector, government contracting deals that are being scuttled or being abandoned due to national security grounds. These deals are, for example, Ant Financial Services Group attempting to purchase MoneyGram, a money transmitter. Broadcom attempting to purchase Qualcomm, semiconductor companies. HNA Group attempting to acquire Global Eagle Entertainment, which for any of you who have taken a flight recently, Global Eagle Entertainment does the in-flight internet connections. Those deals were all abandoned in the last 18 months because of the national security risks that existed due to the transaction, due to foreign ownership in these U.S. critical infrastructure industries that are highly dependent on data, cognitive computing, technological advances. Now, why this has occurred is because in the current regulatory environment, FIRMA has established that if an acquisition creates any new U.S. cybersecurity vulnerabilities or may exacerbate existing ones, then there is national security risk in the transaction and the execution of the deal may be at risk. If the cross-border M&A deal exposes PII, PHI, genetic, biometric information of U.S. persons, the deal may be at risk. We recently saw this over the last couple of months with GNC, which is a health and supplement company, taking an investment from a Chinese investor that needed to go through the CFIUS process because of the PII risk and the fact that there are over 100 GNCs that exist on U.S. military bases. So as practitioners, as attorneys, as consultants, and as in-house counsel, companies need to be aware that the compliance issues related to FDI into the U.S. expand far beyond what people traditionally thought of as defense industrial-based sectors, energy sector, and government contractors, real defense companies. The third bullet is an increased cost to the U.S. government of acquiring or maintaining systems for defense, intel, or national security. And the fourth relates to cumulative market share, shifting that responsibility. So during a cross-border acquisition, another part of the equation for the U.S. government is understanding what and who that company may provide products or services to, and if that product or service is to the U.S. government, intel agencies, or the military, and how that may affect the supply chain in those different industries. Now, as we move forward, what I really want to highlight here is understanding the execution risk of a cross-border M&A deal because of these regulatory requirements. I think we've moved past the days where enterprise deal value really led and was the end-all be-all of an M&A deal. Enterprise deal value matters, but understanding that there is an increased execution risk with some of these industries, with some foreign acquirers, and with some investments into the U.S. needs to be part of the equation as practitioners move forward. And that moves into using compliance as a strategic aspect of M&A deal flow, particularly in these tech industries where these are data-rich sectors and data-rich industries that are very prone and very vulnerable to using AI, using cognitive computing to manipulate data to an end cause. So organizations and practitioners must realize that these national security risks exist early in the deal, understand how to perform a risk-based assessment upstream and downstream with suppliers, with subsidiaries, with customers, and then evaluate what the consequences would be as the deal may move forward to execution. Now, as a country within the United States, that threat landscape has evolved for not only adversary countries, but for near adversary countries where we're weaponizing information, weaponizing data sets, and within this data economy, companies need to make sure that these national security compliance aspects are an essential part of their strategy and understanding how to move forward, how to get deals done, and how to shift from a negative FDI in Q2 of 2018 and balance the open investment policy within the U.S. with ensuring national security within the country. I'll now move to the next presenter.
Thank you, John. So you've heard a lot already about some of the compliance concerns, and I'm going to highlight just a few that are of particular importance to general counsels. I think it's because I think they're a little more, they're like somewhat more discreet than the issues we talked about at a more higher level. You can see, I think everyone agrees that there are going to be legal and compliance challenges around implementing AI. And I'll just hit a few in particular, being sensitive to the fact that we're getting later in the program. One that's less of a compliance challenge and more of a sort of regulatory legal landscape is something you heard mentioned earlier. Who's liable for the AI if there is a problem? Is it the company using the tool? Is it the provider who supplies the tool or is working with you to use the tool? Is it the individual or entity who has provided the data set? You see some of the other concerns there, one of which you've heard a couple of times, which I think bears repeating, is reconciling these multi-jurisdictional regulations, particularly for due diligence, where you have jurisdictionally dispersed documents, jurisdictionally different and potentially conflicting privacy legislation. We've talked already about GDPR. I don't want to go too much into it. Jurisdictionally different intellectual property protection. You're receiving data from different sources. You heard about potential geo-blocking and the potential issues created by receiving data or using data as part of your inputs from different countries. There's a privacy and security issue, which we're going to talk about just shortly for a moment. And then there's the bias issue that we talked about also, skewing the inputs to either intentionally steer certain outcomes or subconsciously steering the outcomes, or having a result that is the product of, as we talked about, the data coming from different sources, different countries. So I just want to highlight one or two quickly, being sensitive to the time. You heard AJ talk about encrypting the data and some of the challenges around data privacy and security, but I think it's important for general counsels to really understand how and why this becomes an issue. AI is still a relatively new concept, and the adoption of AI is slower than I think we'd all like to see it because of its usefulness and some of the challenges that the other speakers spoke to. But in the AI industry, most developers are focusing their efforts on becoming first-in-class leaders, obtaining that first-mover advantage, and of course the financial and reputational benefits that flow from that, and which are sometimes conferred through patents to the extent that they're available, as Eric touched on earlier. So data privacy and security often become refined in later versions or rollouts of the particular products. It's only at that later stage, though, that bigger, more institutionalized financial services companies like your investment banks who might be helping you on your cross-border deals, or large law firms or corporate clients become more comfortable with the integration of an AI platform in their deals. So the other issue I wanted to touch on is liability. You heard about it a couple of times in passing today, and I want to drill down into it just for a second. I have here an example of a healthcare situation. If an algorithm malfunctions, the resulting damages to a company, or if you're thinking cross-border deals, to a public company or its investors, could be disastrous and catastrophic. In the healthcare context, just to concretize this, you could see some of the AI offerings for dosage determinations, helping physicians determine scan recognition diagnoses, of course, and then recommending courses of treatment in particular is a popular area for focus, including, I know Microsoft has a product in this area that purports to have included or quote unquote read and learned from every single cancer paper that's necessary to help physicians formulate the right treatment for cancer patients. Given that there are 800 medicines and vaccines to treat cancer, that's a very difficult process to make that correct determination on which are the right drugs for which patients. And without the medical judgment from humans, a balance needs to be achieved. As you heard, until recently, I was the general counsel of Advanced Accelerator Applications, which is a pharmaceutical company. We were publicly listed on NASDAQ and recently sold to Novartis for $4 billion. When I think of the context of that deal, for general counsel and their boards, if you're relying on AI, the thought of how does this impact our fiduciary duties, particularly in light of uncertain liability landscapes from one jurisdiction to another, and in the face of a potential securities or shareholder lawsuit, AI made me do it, might not be, or AI told us to do it, might not hold up. So should we trust machines and their decisions when these damages could be so important? And how do we understand that landscape? We look to tort law for general counsel and regulators. I think the first question has to be liability. When state-of-the-art AI systems make mistakes, who's responsible? What are the damages? Again, I think all commentators have agreed that at some point machines make mistakes, and the damages will need to be quantified and allocated for companies and general counsel determining whether or not to use AI and which AI to employ. What are the expected damage calculations? What are the worst case scenarios? So regulators and general counsel will really need to make their decisions on deal selection and AI usage and respectively regulation based upon some of these considerations. If AI makes a mistake, what kind of mistake do they make? What are the resulting damages? And all of this is amplified, as you just heard, by the fact that there are these differing jurisdictions with potentially different legal landscapes, regulatory landscapes, et cetera. So in our healthcare example, a physician signs off on the course of treatment. If you think of a CFO and financial statements for publicly traded entities, a human being in each of those cases makes a final decision, signs off on the final answer, and most importantly is responsible for the ramifications of any error. So how does that play out in the AI context? I think it's particularly difficult when you look at the reasonableness standard, because AI raises significant challenges to traditional tort law reasonableness person standards, which is it's unclear in the context of software design at times. And then the final issue that I'll touch on is bias. Again, if you think about whether AI algorithms introduce bias and how that happens, we've talked about those sources. Think of the Google issue recently, whether it's intentional or unintentional, just based on the scale of big data being used and the sources where it comes from. So with that, I will turn it back to the program moderators.
All right. This is AJ. Thanks, Edward, John, and Eric. We had a few questions that we were considering, but now that we're over time, we will pause here and see if there are any questions we need to answer from the audience, and if not, we will proceed from there. Okay. In the Claire or Kelly, any questions that we need to answer from the audience, or how would you like to proceed given our time limitation?
It looks like we're having some audio and video technical issues at this time. We do have text on it, so just bear with us, ladies and gentlemen. I have posted a note on the webinar platform for the audience as well. We don't want to close out. We want to make sure everyone is able to get their evaluation.
Okay. While we're pausing here for a second, I guess I'll continue to wait, but happy to pose some questions just to keep open dialogue going if we want to do that while technical difficulties are. Okay.
Definitely, go for it.
So for the panel, what are some key security issues that you might see in your practice regarding the use of blockchain across borders or other technologies that you see are being used with artificial intelligence?
This is Eric. I've seen some specific issues from the nature itself of the blockchain technology. It's they are distributed ledgers which are not hosted and controlled by a single entity, and where you have sometimes nodes which span over several countries. While it does provide some inherent safety, the very nature of these ledgers may eventually make it difficult to maintain. For example, how do you upgrade security or patch a security hole when you do not have a single copy of the ledger, but several copies in different countries? Then also, while the hashing function of the blocks themselves are generally thought as secure, blockchain technology does not live in a vacuum. There are input and output functions which often rely on encryption process, such as the very well-known elliptic curve cryptography. These are often susceptible to some attacks, such as network protocol flaws, exploiting backdoors that are left in the encryption method. Even in some cases, as we've seen in the past, for example, with the DAO and the Ethereum, the past Ethereum Bitcoin cryptocurrency. The programmable blockchain technologies themselves allow operations which may be beyond their initial design, some undesired operation. So all these issues have to be assessed from the technical standpoint, and when we're looking at the security, the safety of the tools that we're using cross-border, there's the notion that we might have different solutions in different countries, but also the fact that the technology itself is operated through several countries is a challenge by itself.
Thank you, Eric. Any other panelists want to chime in here?
AJ, it looks like we are back live. And if we have no questions from the audience, it looks like we will conclude the presentation then. Ladies and gentlemen, we would like to thank you, and to our presenters, we thank you for the presentation. We hope everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg Law webinars by accessing our store at learning.bloombergnext.com. You will currently see instructions on how to earn credits for attending today's webinar. Please fill out the webinar evaluation survey as well as confirm your certificate information. Some jurisdictions may take 4 to 6 weeks to receive credit. You will receive your certificate via email when it is available. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I want to again thank World Services Group for sponsoring today's webinar. Thanks, everyone, and enjoy the rest of your day.